Welcome to Guardians of Innovation, Patent and Trademark Law with Vincent Lotempio. Join us as we dive deep to help inventors and entrepreneurs secure and profit from their valuable ideas.
Hi, welcome to Guardians of Innovation, Patent and Trademark Law with Vincent Lotempio. I'm Matt Sky. With extensive experience in patent and trademark law, Vincent helps inventors and corporations profit and secure their valuable ideas. Vincent, thanks for joining us.
It's always enjoyable talking with you.
Definitely. So let's get right into it. What key steps should an individual or business take to prepare themselves before pursuing a trademark registration? And why is that preparation process so crucial?
Well, there's no one thing, but certainly the most important thing is that you're not using somebody else's. So the first step is the search to make sure that what you're using is distinctive. You know, where did they come up with the word branding products from? You know, the first cow that got branded, right? To separate your cow from everybody else. So separating your product is distinctive. So when the consumer sees it, they recognize that this is from this particular source, from you. And the same thing when somebody else tries to copy your idea, you're the manufacturer, you know, you can identify that they're using your mark, that it's a distinctive mark. You know, one of the problems that, you know, people want, especially with SEO now, they want to have something that what's being typed in there as their trademark. But you can't register descriptive words. And I think the first thing you have to figure out is coming up with that distinctive mark.
So, Vince, can you explain the importance of seeking legal advice when dealing with trademarks? How does having an attorney set you apart from just filling out a form online, which so many people do?
You know, that's kind of my trademark. I always say, look, it's more than just filling out a form. It's all the legal advice that goes along with it. You know, and I've come up with this model of being an attorney when I first started, both for patents and trademarks, of coming up with a flat fee so that you're not nickeled and dimed every time, you know, you pick up the phone and call. And I say my job is more than just filling out the form, is to teach you the proper way to use the mark in commerce, to put it on your product, to use it to advertise your service, whatever that is. And if you don't do that right, then you're not going to get the trademark. It's going to be rejected. And there's a misnomer. Even lawyers ask me, how do I trademark something? Well, you by filing an application to register your trademark, that's not how you trademark something. You trademark something by using it, by putting that mark out there and let people recognize it. Let's say you're Coca-Cola, and in 1901 you started selling bottles of Coca-Cola, and you never thought it was a good idea to trademark something, and that you never registered it and didn't know the value of it. And in 2000 you still hadn't registered it. But yet you've had a pop machine in every single podunk little gas station across the country, across the world, and you've used it in every grocery store in every part of the world. You would have what's known as common law rights in that trademark, because you'd have superior rights because you used it first. So the more you use it, the more you have rights for it. So what happens when Coca-Cola decides, yeah, we should probably register this mark, it's probably a good idea? Well, what registration does, it puts everybody in the country, you know, because trademarks are local, it's for per country. You could do some European stuff, but let's just stick with US. So you can put everybody in the country on constructive notice that this is your trademark. But you've already put everybody on actual notice on commercials and billboards and bottles and pop machines. Everybody's seen the Coca-Cola bottle already, but you're not Coca-Cola, right? You're just starting from scratch. You're selling in your little local municipality. You're putting a sign up on your brick and mortar. Well, people in Chattanooga, Tennessee, or Podunk, Illinois, they never heard of you. They never knew about you. So when you register it, you're putting everybody in the whole country on notice that this is your trademark, and nobody can say, well, they didn't know about it because you've been registered. So registering your trademark doesn't get you the trademark. It just puts everybody on notice that this is your trademark.
So using it is part of the process, and putting it out there, implementing your trademark in an actual real world scenario. But are there other techniques people can implement to avoid infringement issues and disputes in the future?
Yeah. So let's just say you haven't used it, right? You've never used the mark, but you've come up with this great idea for the new widget, and you're going to call it, the XYZ widget, whatever name you're coming up with it. You think it's a great name and I want to protect it. So you can file an application that's called an intent to use in the future. So now, remember how I just said that you put everybody on constructive notice that it's there? Well, this is considered a constructive use of the trademark. So in order to protect your trademark, it has to be used in commerce. So the federal government gets its rights through the Commerce Clause of the Constitution. There has to be commerce to be federally, that's why, bank robberies are a federal offense, or it's crossing state lines is a federal offense. It's through the Commerce Clause, right? So when you start using your trademark, the trademark can give you a registration for it when you're actually using it. But if you want to preserve the rights, what they'll do is they'll do a search on your intent to use application. Then they'll say, if you have the rights to do it because we did the search and we didn't find out that anybody else is using it, we'll give you 6 months from today's date to show us how you're using it in commerce. And you have to actually sell a product, sell it in commerce with a label on it, and then you have to submit it to the trademark office. Well, maybe you're asking the question, well, I haven't used it yet. We just got done saying whoever uses it first wins the race and owns it, whoever uses it first. What happens if somebody sees my application that's been published and they go start to use it right away? Well, your date that you file it becomes like the absolute date of constructive use. Although that use won't get you the trademark registered, you're still going to have to sell it. Anybody that wants to say that they're going to be injured by your trademark, or that if you get this registered, it would be a problem, the patent and trademark office would say, okay, who used it first? Who sold it first? Who had it out there in the market first? That intent to use application will be the date that they'll go by. So that person that started using after you, they would lose the race and you would have superior rights. They'd have to still prove that they used it prior to the date that you filed your application. The common pitfalls really are picking the wrong trademark because they're not distinctive enough, or people think that if I just change it a little bit, I won't be infringing. Like if your trademark was crystal clear, water, right? Or crystal clear cleaners or something. And you spelled it with all C's. And I say, oh, I'm going to copy that. I'm going to make it all K's. The trademark office would say that's just the equivalent. It's a phonetic equivalent. The rule is that the consumer is likely to be confused. So when the consumer goes in and buys a certain product, if they see your product and their product right next to it, would they be confused as to who the source was? When a client comes in to me and says, does this look too much like the Coca-Cola bottle? I say, if you got to ask the question, then it probably does.
It's a great point. It's a very logical question. How do trademark searches and the navigation process become easier with an attorney?
Well, like I said, you can do a search to have a knockout. And if the knockout doesn't come exactly like you have it, you might think that you're covered, right? And if you go in the patent and trademark office and you do the search, you're going to see all kinds of warnings that even though you didn't find the trademark that you just typed in, doesn't mean that you're still eligible. Because what I do, and we do an in-depth search report, it's usually 10, 15 pages long. We go through everything we find. We're looking for anything that's close, anything that's confusingly similar. And then we make that opinion. And I don't want to sound like I'm bragging, but 98% of the time, there's always one or two that slip through. We do the search and we're pretty much right. It's a little different than patents. The percentage isn't that high, but usually we have a pretty good feel for it. There's never a 100% guarantee in anything. This is all opinions too. And sometimes our opinions differ from the patent office, but you could have Domino's Pizza and Domino's Sugar. Nobody's confused. But if Domino's Pizza wants to start selling Domino's sugar or salt in the sugar aisle, there's going to be a lot of confusion and there's going to be a lot of problems and there's probably going to be a lawsuit.
How would Domino's be able to sell sugar if they wanted to? Just a hypothetical.
Yeah, they'd have to probably change their name. If my name was Paul McCartney, I couldn't register the trademark for Paul McCartney and start singing songs. It's distinctive. The whole idea is you can't confuse the public. So the trademark office, the patent, the government wants to do the best for society as a whole, protect the individual and protect the company, the big corporate client, both at the same time.
So what should be considered when choosing a trademark, and what makes a strong and memorable trademark?
Yeah, I always say it's got to be short and sweet and easy to type in. And there are basic fundamental principles. And I wrote a blog article in my blog about the spectrum of distinctiveness. And there's 5 levels of distinctiveness right off the bat. So now there's 2 types of distinctiveness. There's acquired distinctiveness over time, and there's inherent distinctiveness before you ever sold a product. It's just distinct on its own. So right away, if we've never used it before and we want to create a distinctive thing, we have to look at this spectrum of distinctiveness. So it starts off with generic, and you can never, ever register something like generic, something like soap, right? I can't own the word soap. If I want to sell a bar soap or soap, dishwasher soap, I can't stop other people from using soap. So right away, we know generic things are not registerable. Second is descriptive. Now, descriptive marks like maybe Open MRI or something could start off as being just descriptive and not registerable, but they could acquire distinctiveness over time. So they say like a surname isn't distinctive because everybody's got the name McDonald. So maybe when McDonald's or Best Buy, you're just saying I have the Best Buy, when they first came out with their registration, it was just a descriptor saying we have the Best Buy. But after they put their name on the billboard and they sold 87 billion hamburgers, they've acquired distinctiveness over time and they became a very strong trademark. But when they first came out, the day one, when nobody ever saw it before, it was a weak trademark. It was on the weak side of that spectrum. The next one is called suggestive, right? Dunkin' just changed their name from Dunkin' Donuts to just Dunkin'.
I've been noticing that, yeah.
Yeah. So what are they selling? What are you dunking? You're Dunkin' Donuts and coffee, right? So it's suggestive of it's creative, it's suggestive, it's one word. That's the type of trademark you want to come up with. A lot of people want real descriptive marks because that's what people are typing in the search engine. I want this. But those are very weak trademarks right from the get-go, and it's going to be hard for you to acquire distinctiveness if it's just describing what you're doing anyways. And you can still use all those search engine words on your website still because they're just descriptors, but you want to be distinctive. So I try to tell people to, because they always want to be descriptive, to try to lean towards that creative suggestive. The next one is the number 4, one of the strongest ones is arbitrary. I arbitrarily put an Apple on a phone and a computer, and I call it Apple Computers. Apples have nothing to do with computers. It's an arbitrary name. It's very distinctiveness out of the box, right? Inherently distinctive. Of course, they have acquired distinctiveness over time by using it in millions of iPhones, but that's called, arbitrary. Then finally is fanciful. You just put 26 letters in a box and you pull out Zillow or Google or Exxon or Xerox. You just make a name up. And those names, nobody wants to do that because right out of the box, nobody's ever heard of it before. Nobody's searching for Exxon or Ziplik or whatever. You come up with some crazy name. So nobody ever wants to do that. Nobody ever wants to do it. But if you do that and you build a strong name like Google, or Amazon, well, Amazon would probably be arbitrary because it's not a made-up name. But those would end up being, for sure you'd get them registered because they're so unique that you just made up a word. And then it's still going to be your job. And we talked about before, you always have to do 3 things. You have to be able to manufacture, market, and distribute it. And you're only as strong as your weakest link. It's going to be your job to market it and to get that brand out there. But, why not start with a very strong brand?
So when we get into another world, counterfeits and people infringing on trademarks, how can businesses proactively monitor and protect their trademarks?
Yeah, that's such a difficult thing. And again, I have the client that did the selfie stick, and he called it a monopod. I wish he would have called it a selfie stick right from the start and we could have registered that. But, what we did was we'd go on Alibaba and we'd go on all these Amazons and find those. And now Amazon, and I know I talked about before, I probably picked the right time to become a trademark attorney or a patent attorney. Amazon is requiring that you brand your product. You have your branded product and you have a trademark registration. Because it was in the past, like 10 years or so, we would just send out, cease and desist letters and demand that Amazon takes these things down. And they didn't want to get in the middle of it, and they didn't want to get sued from either side. And all these people making decisions aren't lawyers. It's not like being a judge. So what they decided was, look, you can't even put your trademark up there unless it's branded, unless you filed a trademark application. So one of the things to do is, have your unique, distinct trademark, have it registered, and then all you have to do is show Amazon your trademark registration certificate, and they'll take the opposers, the competition's products down, and we've done that a lot.
So that's actually a relatively new development then, right? Requiring that trademark proof from Amazon?
Yeah, relatively new, a couple of years. And the reason I know is because as the person who registers the trademark, for some reason, they don't even ask the owner of the trademark. They want the lawyer's office to verify that's the client and that they own the trademark. And I have to, basically indicate to them, it's not like an affidavit or a sworn statement, but I just send an email saying, yes, that's my client. Yes, that's our trademark. This is the confirmation code. And there's this long confirmation code that we work with. So I'm constantly helping clients become branded on Amazon.
So what key advice do you give individuals or businesses who are considering pursuing trademark registration or legal assistance with their trademark matters?
Well, again, I think it starts with the search and starts with, reputable attorney that you're working with. I try to compete with the big firms by basically giving a flat fee in a reasonable amount. And when I say a flat fee, I say, look, you can call me anytime you want. I give them my cell phone number. I let them talk to me. I say, look, if you can't get a hold of me, I have a link right here. I'll text it to you to my calendar. If I don't pick up the phone, because I'm talking to you on the phone right now, and if somebody else was calling me, I wouldn't hang up and talk to them and hang up on you and talk to them. So just, have somebody that you can communicate with and is there to help you. So those are the type of things that I would want if I was on their side, and that's what I tried to provide for my clients.
That's interesting that you make yourself available like that. How much does that make a difference for clients?
I think it does. I think the biggest problem with attorneys is the lack of communication, and we're so busy that it's like you're inundated every day and you're just putting out fires. And again, I always talked about my wife, but she'd always tell me I have to be more proactive than reactive, but my whole life is reactive. I see a problem, I go try to fix it, and right now I'm being proactive. I'm getting on a podcast, I'm creating this, and people say, how do you have time to do something like that? And I think, the podcast is a great way to meet people. It's you can get a feel for who I am and just talk to me, and that's the beauty of the internet. I literally have clients from France, Russia, from all over the country. I keep saying one of these days I'm going to figure out how many states I'm in. I'm sure I'm not in all 50, but I'm pretty close. But just because the internet makes me available. So in the old days, I'd be in church and say hello to somebody and say, what do you do for a living? I'm a patent lawyer. Maybe he knows somebody. Now I get on a podcast and 35 million people, if they wanted, could see me. I don't know if that's how many are going to watch this, maybe a couple thousand. But on my YouTube channel, I get close to 300,000, viewers and followers. And so to me, this is my way of saying hello and getting to meet people.
It's a surreal new world how we're connecting. Definitely. So if you had one last piece of advice or a key takeaway as we wrap up, what would that be?
Yeah, I think at the end of the day for trademark is get that registered right from the beginning and get it done quick. I don't know how many times that I've seen people come a month late and somebody has just registered it before them. So my thing is get it done first. One of the first things you do. Don't be penny wise and pound foolish. Get it done. It's worth a couple $100 that you pay for it. I keep it under $1,000 is the total fee to do it, and that includes the government fee. So get it done quick.
That's great advice. Everybody, thank you so much for joining us on Guardians of Innovation. For more information, to connect with Vincent Lotempio, find him on social media. I'm Matt Sky. Vinny, thanks for joining us.
Hey, Matthew, it's always a pleasure talking with you. I enjoy speaking about intellectual property with you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.